Great.
Thank you. I will now ask the attorneys in 125-637 State of Kansas versus Danny K. Williams to please come forward. Approach as soon as you are.
Ready?
Yes, I
Okay.
think so.
I'd like to reserve 3 minutes, please.
All right, 3 minutes is reserved.
Again, good morning. May it please the court. I'm Joe Dash, I represent Danny K. Williams. Facts of this case are pretty simple. There were two teenagers that were having some sort of a dispute. They brought their teens and one adult into the mix, which resulted in the tragic death of one of the teenagers occurring during a shooting car chase. Danny Williams was convicted or charged in the death of both felony and premeditated murder, and was convicted of each. 3 people were charged in the death and tried separately, with Williams being tried on an aiding and abetting theory. Mr. Williams' case, the state offered and published to the jury after it was admitted a video of the victim being treated for his fatal injuries at the scene of the crime accident, because there was a car accident which preceded his death. Appellant here asserts that the admission of this video is erroneous due to its prejudicially gruesome nature and complete lack of relevance or materiality to the state's case. Appellant would respectfully submit this error was principally due to the district court's failure to review the video prior to its admission and when the objection was lodged. Video itself, well, it speaks for itself. And I apologize for my late request to view it, but well, we're not capable of doing that here in the court, or it's just not that important because you all will have watched it. I certainly know that you will have, which is a lot more than the district court did beforehand, as she didn't watch the video before admitting it.
Let me ask you this.
Yes.
The one note that I put down in my papers when I was going through this. So, we've seen arguments about autopsy photos being too gruesome to be admitted. And I'm not sure I've ever seen a case where that argument prevailed, certainly since I've been here. So what's the difference with what you have with something that we've considered before and kind of uniformly rejected?
Difference here, Your Honor, is that we're not talking about the dry and clear pictures. We're talking about watching a child die in front of you, which if there's a dying declaration or something like that, or as I've experienced in other cases, I'd understand that. But there was no probative value whatsoever to this case, none.
Let me push back on that a little bit. I've seen the video, and I agree. I mean, it's a tragic circumstance, right? But it's tragic, gruesome crimes create gruesome images. At least our case law suggests that. But when you watch the video, you can see as the officer approaches the vehicle, bullet holes in the window. Then you see it is an occupied vehicle and the victim that has been shot. Here, the felony murder, or at least the felony underlying the felony murder charge, is unlawful discharge into an occupied vehicle. Seems to me that the video is quite relevant to the elements of that felony.
Well, how I'd reply to that is, at what point does it retain that relevance when you're getting into the car and seeing this person? The state's proffer at the time of trial was, well, it's going to show his position in the vehicle. That's irrelevant. That's just a stupid argument, to be honest. There's no importance to where he was in the vehicle. He was shot, period. If he was in the passenger seat, if he was in the back seat, well, it wouldn't matter. Anybody that was shot in that car was shot in the car, inside the car. And the second argument made by the state was that, well, it shows where this handgun was found. Well, actually, the video doesn't show where the handgun was found. There's some hearsay statements of where a person came in and said, I put this gun up on the dash of the car, or not on the dash, but on the hood of the car. That's irrelevant too. That has nothing to do with whether Mr. Williams, what his participation was in this crime, what
It corroborates their motive.
I'm sorry.
But doesn't that corroborate the eyewitness testimony who said they saw him in the vehicle driving the car and the
As far as I'm concerned, and I know that that's not necessarily what the state has to prove, what does it matter? The case was that one person shot into the car and killed them. But what led to that shooting really doesn't make much difference. I mean, it does in some respects to show the general outline of what's going on, but when you see the actual other videos in this case that show that there's a man shooting from the top of the car, shooting into this car, I don't think there's really anything else that they needed. So is it cumulative? I guess that's not an argument they made in the district court. They didn't make many arguments in the district court. It was a very unusual objection.
isn't the fact of retaliation relevant to of the people who were shooting at the
I would say, honestly, Your Honor, I would say that goes to, and I'll concede in some respects, yes. But also the question is, what was the intent of Mr. Williams as it related to Mr. Johnson's decision to take an assault rifle and to shoot at these people? Now, had there not been an assault rifle, and I wasn't going to go on this bandwagon, but I will for a moment. Had there not been an assault rifle, we'd have a different picture entirely. That death would not have occurred had we not had an adult that decided to come, I'm going to join in and kill somebody. We'd have had two kids that were shooting in the air like they were to begin with and driving around like idiots. Probably not likely they would have shot into the back of the car and killed anyone with a handgun. Not likely. Now, I didn't want to get on that bandwagon, but I'll just say that there's really no reason this had to happen. And there's really no reason that this did happen other than one person, Mr. Johnson, decided he wanted to join in and kill someone. I don't think that the intent of Mr. Williams was to kill anybody. It was to go scare somebody. See, you slid in another part of this transcript. He slid up on me. I want to go slid up on him. Okay, do the same thing, not shoot and kill him. However, that's what we're dealing with right now because somebody tragically died because of the decision of one adult and to join into two children's squabble.
Can I move you to the, you brought up the issue of it's an abuse of discretion
Yes, sir.
for the trial court not to have viewed the video prior to its admission or taking up the issue. And as I understand it, the issue was brought up pre-trial, the gruesome nature of the video, or was it done during trial?
Yeah, well, okay, there's a problem with that. The first lawyers in the case brought up the gruesome autopsy photos as if they would be gruesome, not knowing whether they would or wouldn't.
Okay.
That was deferred to trial on gruesome photographs. This was not really raised until the video came to fruition and was admitted. Unfortunately,
So are you saying defense didn't view the video either before it was admitted?
I
It
think she
wasn't part of
did.
the discovery?
Yes, it was part of the discovery, and I believe she did view it, but I do not believe that she made an objection she made an objection before it got on, but there was no pre-trial objection. It was made within the middle of the trial. So it's an unusual situation. Well, it's unusual in two respects, because it's a video and of what it shows instead of what it shows, that it doesn't show the results. It shows.
Do you have any support for your proposition, I suppose, or your position that a district court must view evidence prior to its admission? A proffer isn't good enough. Essentially, that's what you're saying by if the district court had bothered to look at the video, absent that, it's an abuse of discretion.
Yes, that is the position I'm taking. Why am I taking
Explain
that?
to me.
Because
You don't have any case support.
no, I don't.
Okay.
It's a district court's job to review evidence for gruesome decision. It's got to make a decision based on its own information. The proffer was not accurate whatsoever. It was not accurate whatsoever. It said, well, it's just going to show his position. Who cares? It really showed, it showed a tainted crime scene where two people were already in there taking care of this kid, trying to take care of this kid. And I'm sorry, I'm being cavalier. I'm not trying to be. It It did not show what the state suggested it would show, or if it did, that was immaterial to its case. So being that, and I'm gonna get to the point, I'm getting there. What should a district court judge do when they're, approached with an objection to the gruesome nature of photographs? Should they take the state's word for it, or should they actually do the job and review the video beforehand, determine what it looks like? Because there was no suggestion on exactly what was going to be in the video. It said it's gonna show the position in the car, and I don't know if he actually said the part of that, the gun, or not, when he made the proffer. However,
Well, it
what is
doesn't,
the judge supposed to do then?
it doesn't change the standard of review that we have though,
that's true.
which is
Mhm.
we have to review it for abuse of discretion.
Right.
It either was or wasn't.
Sure,
That's based only on what the evidence shows.
that's true.
How do you respond to the state's argument that your arguments as to relevance of the body cam footage was not preserved because there was only a contemporaneous objection to gruesomeness and not to the relevance at trial?
How I would respond to that is that part of the standard review, and it's part of the thing that it's part and parcel of the review process you should make before admitting evidence. Evidence must be relevant, and it must be more probative than prejudicial. That's part of the initial, it's part of the whole thing. And you can't parcel out that particular argument simply because they didn't make that. They asked for gruesome instead. I'm sorry, unduly prejudicial. That's part of the argument. It's part of the unduly prejudicial analysis. So I think you have to make the relevance argument. And whether she did or not, whether her trial counsel did or not, I had to make that argument no matter what, because it's part of the analysis. So I apologize for bringing something up that we take what we're given when it comes to an appeal, and I did what I could with what I had. So that's what I can tell you with that. With that, my time is about up, and I think I've made the arguments that I need to make. I will say one thing, and I did make a note on this. How would a reasonable person rule on the probativity of evidence if it doesn't look at it? And that's the reasonable person standard we're talking about. How would a reasonable person decide what they're going to do with something if they never looked at it? So that's why I think that there's a built-in abuse of discretion argument there. District court can't make a ruling on a prejudicial nature of a video if they don't look at it. And it's published to the jury, so it's already out of the bag. So a decision after the fact that was made here isn't appropriate or legally adequate under the circumstances. And with that, my time is up.
No questions. Thank you.
Thank you very much.
Good morning. May it please the court. Again, this is Jody Litfin representing the state. I guess I'll just hit on the preservation argument, and I would agree with what you were saying, Justice Wall, on the relevance part, as that was not preserved. In our view, if you're going to get to more probative than prejudicial, aren't you saying it's already probative? You know, isn't it already relevant? And then we have to decide whether that relevance or probativeness is outweighed by the prejudicial effect. So we would stand by our preservation argument that the only thing that was really ever argued, because this was an objection, it wasn't even an objection, it was, can we approach, it was a request for a bench conference. And then defense counsel basically said, hey, there's this video. There was a motion for gruesome photographs that was, pursued earlier, but this video is probably going to be graphic. I don't know. And then the prosecutor made their proffer. So the state.
Had anybody viewed it besides maybe the prosecutor and obviously the proponent of the video, the detective or whoever is testifying to the officer? Had anybody viewed it prior to its being shown in court besides the state?
I don't think that anything in the record says that defense counsel viewed it. I mean, I would imagine that it was a part of discovery. There's no discovery, issue being raised here. She knew about the video.
The way you said it, you prefaced just a minute ago, it's probably gruesome. I mean, that indicates to me that if that's how it was, if that's what entailed, if that's was the discussion at bench conference, it doesn't sound like there's any specific pointing out that it is.
And Your Honor, I can't tell you, I mean, I don't know whether defense counsel watched it or not. She just said, obviously, this is a body cam video, which I'm going to anticipate is going to be pretty graphic. I don't know. So
Anticipate.
I
Okay.
don't know how that's a relevance objection.
Right, no,
So I guess that's just my point in the
Okay.
preservation part. And this kind of points out the importance of preservation, because had there been some sort of pretrial hearing on this, the court could have watched it. But this video wasn't raised pretrial. It was the gruesome autopsy photos only. And that really resolved itself because the parties said, yeah, we can come to an agreement on these autopsy photos. We'll let the court know if we can't. And that was that. So we don't believe relevance was preserved, or the defendant's argument in his brief that this was cumulative evidence. So our position would be for this court to really only address whether this was unduly prejudicial. And our position again is that it's not.
But on appeal, we have to review both, right? I mean, it's a balancing question. So maybe the particular arguments that were raised on appeal as to relevance could be susceptible to a preservation argument. But in terms to understand where the district court properly exercised her discretion, we have to consider both, right?
She did make a relevant finding.
Right.
So, I mean, yeah, I think,
And isn't on preservation, isn't it really just whether the district court had a chance to rule on the grounds that are being asserted?
yes, Your Honor. Well,
I mean, I would word it that way, and it seems to me the district court not only had a chance to rule on relevance, but actually did in the process of overruling the group. It just seems like this isn't the best hill to die on.
and we did address in our brief the merits of everything. So yes, I mean, we would agree that the court did find it was relevant and more probative than prejudicial. And I don't believe I have any further comments unless this court. We would just ask to affirm the premeditated first-degree murder conviction in this case.
Let's see, no questions. Thank you.
State seems to suggest that relevance is built in. I would suggest that's not correct, especially under this analysis. The question of gruesome photos was deferred by the judge prior to trial. It was argued but deferred. Now, that was photographs, and this is a video. That is the difference. I would also suggest the relevance finding of the district court was based on the proffer and the proffer alone. And I do not believe there was actually a prejudice, probative over prejudice ruling. There was a relevance ruling. It's relevant. And there's always gruesome, so I'm gonna let it in. But that wasn't based on any actual viewing or review of the evidence. So I'm gonna suggest that relevance finding was not based on it was only based on the proffer of the, and that's actually made out in the briefs completely clearly. Based on the state's proffer, I'm gonna find it's relevant. And that's the only relevance finding made. It wasn't made on the evidence itself. So that's all I have to say. Any other, if there's no questions.
I just had one question about the record that can help me clarify. There were autopsy photos that didn't come into evidence.
That is true.
And was it because the district court judge said, hey, this video's enough, we're not going to get into? Was there an actual ruling, or was it made clear enough from the record that the state wasn't going to put on additional photos of the deceased because the video itself was adequate?
Yes, during the mistrial motion the following day, she made that ruling. The district court made that ruling. And I believe that is correct.
Other questions? Thank you.
Thank you very much.
Thank you to both of you for your arguments this morning. The court will take this appeal under advisement.